Good afternoon, everyone. Thank you for joining us for today's online talk. We'll be starting shortly at 3 o'clock. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on a bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Setting Aside an Adjudication Decision, Can It Be Done? My name is Wong, Chee. I'm an associate with Marvin Coy & Associates, and I'll be your moderator for today's session. Today's talk is part of our MWK online talk series. By way of background, we have been organizing a monthly lunch at our office since 2013, some of which were broadcasted live. But with the COVID-19 pandemic, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. This is our third talk in 2022 for our online talk series, which has been attended by some 3,000 attendees. Before I continue, please be reminded that this talk does not constitute legal advice. In the event that you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Now, let me introduce the two speakers today. We have two speakers. The first is Ms. Denise Phang, and the second is Ms. Hannah Patrick. Denise will be speaking first, followed by Hannah, and we will then conclude the talk with a Q&A session. Our first speaker, Denise, is a senior associate in our dispute resolution department. She was called in the Malaysian bar in 2015, and her area of practice includes commercial contracts, adjudication, arbitration, construction, and land-related disputes. Our second speaker, Ms. Hannah Patrick, is also a senior associate in our dispute resolution department. She was admitted to the High Court of Malaya in 2013 and to the High Court of Sabah and Sarawak in 2017. Her area of practice includes general litigation, construction law, administration of estate, and debt recovery. Now, we have 4 talk points today. The first speaker, Ms. Denise, will be covering the first 3 points: overview of adjudication under CIPAA 2012, how to apply to set aside an adjudication decision, and lastly, grounds for setting aside an adjudication decision. And Hannah will be taking on the last point, which is case studies in relation to this topic. Before I pass on the talk points to Denise, I would just like to remind our audience that If you have any questions, please post your questions in the Q&A section box below. You should be able to see on the Zoom options, the Q&A section, and not in the chat box. And we do anticipate many questions regarding this topic, so we appreciate if you can confine your questions to the topic and the talk points that our speakers will cover today. With that in mind, I will now hand the floor to Denise. Denise, over to you.
Thank you, Chee. Good afternoon, ladies and gentlemen. Welcome to our online talk series. Today, we are talking about adjudication, which is a mechanism under the Construction Industry Payment and Adjudication Act, commonly known as CIPAA 2012. It's usually used by players in the construction industry to claim for payment, and this mechanism is known as adjudication. So adjudication has been in Malaysia since April 2014, and this mechanism of adjudication cannot be excluded by way of contract. So I believe those who are in attendance today actually involved or familiar with the construction industry and construction contracts. So even if, let's say, when a subcontractor and employer enter into a construction contract, they can't expressly in their contract say that, adjudication would not apply to this contract. Parties agree not to go for adjudication in the event of any dispute. So that's what it means by cannot be contracted out. So adjudication applies to all construction contracts in Malaysia, and there are certain criteria which I'll be touching on later. But one of the things to note now even is that adjudication is applicable even with the existence of condition precedents or dispute resolution clauses. For example, arbitration clauses in your construction contract. So nowadays, it's quite common for construction contracts to have an arbitration clause, which to refer the dispute to arbitration. But most of the time, arbitration much longer and it's much more expensive. And to meet the needs of the fast-going construction industry, and so that projects are not delayed and LAD is not incurred, the government has introduced a mechanism of adjudication. And the governing body or the authority that is in charge of procedurally managing the entire adjudication process is the Asian International Arbitration Centre, AIAC, formerly known as KLRC, but now has renamed itself to AIAC. So when we come to looking at adjudication, there are both pros and cons to the adjudication process. But in Malaysia, adjudication is fairly popular. I think at the end of the day, the pros do outweigh the cons for most of our clients. I mentioned before, one of the biggest advantages is it's faster, it's cheaper than arbitration or court proceedings. And there are special remedies available under CIPAA, which only applies to adjudication decisions. I'll touch on that later as well. It's confidential. Your company's dispute won't make the headlines of any newspapers. So that is one of the attractive points of adjudication as well. And some of the cons, I would say, is that adjudication is described as rough justice. So in the sense that the adjudicators appointed are actually a mix of players, for example, surveyors, architects, engineers, and lawyers. There is a varying degree of backgrounds in the selection of adjudicators. The adjudicator might not get everything right, hence that's why it's called rough justice. And at the end of adjudication, one of the cons is that parties might have to go for re-litigation, or they say second round or court, if they are not satisfied with the adjudication decision. Adjudication does offer a temporary resolution, and more often than not, parties get tired after one round of adjudication, and therefore sometimes they don't even proceed with the re-litigation. These are just some of the pros and cons of adjudication. I was talking about what type of contract does adjudication apply to. So CIPAA applies to construction work contracts made in writing. It could be for work, physical works, or it could be for a construction consultancy contract, meaning that even engineering or architectural consultancy contracts are also under adjudication. Let's say they were not paid, even though work has been done, they could file a claim with the AIC to claim for work done. Another condition is that those work done must be carried out in Malaysia, or at least wholly or partly in Malaysia. For instance, some of our clients have works to be done in Singapore and Malaysia at the same time. CIPAA is still applicable to those contracts, and parties can still refer their disputes to adjudication. CIPAA also includes construction contracts with government. For example, contracts for road, construction of roads, public roads, or any construction of any buildings and etc. But there is a special exemption order, which is the CIPAA exemption order. It does not apply to government contracts where it pertains to national security. Now, what is national security? It's vague in the sense that it must not only relate to national interests, but national security itself. So, for example, if the government contracts a contractor to build a hospital, that may be under national interest, but it might not necessarily come under national security. National security might be narrower. For example, if let's say the Ministry of Defense of the government, or specifically the Ministry of Defense, contracts for the construction of some barracks, so that may come under the exemption order. So far, this exemption order is rarely invoked, and most of our clients, if your contract comes under the Ministry of Works, those contracts can go for adjudication as well. Now, what does CIPAA not apply to? There's only one scenario where CIPAA does not apply, which is to a contract by a natural person, which means a private individual, not a company, for a building that is less than 4 stories high, that is intended for his own occupation, which means residential. So if a private individual comes to you and wants to build a 3-story bungalow for himself, so that would not come under CIPAA. And if, let's say, the contractor is not paid, the contractor will have to resort to the usual court process in order to claim for payment instead of going under CIPAA. So this is the only scenario where CIPAA does not apply. Now, this is the more procedural part of adjudication. Adjudication works in this way. Parties will get to file certain documents, time periods set by the adjudicator. And these timelines are also, to a certain extent, provided under CIPAA. And if an extension of time is required, then that will be at the discretion of the adjudicator, and parties will have to apply to the adjudicator. But basically, the timeline is like this. Adjudication starts when the unpaid party serves a payment claim to the non-paying party. And the non-paying party will get 10 working days to revert with a payment response. So that's how CIPAA works. Once the payment claim identifies the scope of what will be referred to adjudication, and the payment response will also determine what the scope of the non-paying party's defense. Sometimes parties may opt not serve a payment response. That's up to the non-paying party. But at the end of the day, jurisdiction is determined at the outset of adjudication by way of payment claim and payment response. So we normally advise client to get it right. Get your payment claim right, and if you have any defense or any set off or counterclaims that you like to raise, you should definitely raise it in your payment response. So from the outset, we will advise client to get the necessary legal advice that they need in order to proceed to defend or to pursue their claim. So once that's done, once the payment claim and payment response is in, what parties can do is serve a notice of adjudication to AIEC within 10 working days and register the adjudication with AIAC. Depending also on parties can choose to appoint their own adjudicator. But if parties can't agree on the appointment of adjudicator, AIEC will appoint the adjudicator within 5 working days of the application. And then the adjudicator will have 10 working days to accept his appointment by way of the notice of acceptance. Once the adjudicator accepts his appointment, then the adjudicator will set out the timeline for the exchange of documents, which you can see on the right side of my slide: the adjudication claim, the adjudication response, the adjudication reply, and optional, adjudicator might also require parties to submit bundles of documents, witness statements, and submissions. At the end of the timeline, once the last document goes in, sometimes the adjudication reply or the adjudicator may ask for an extension if additional documents are required. The adjudication decision must come out within 45 working days. So the adjudicator will usually within 45 working days issue his decision. So the entire process of adjudication takes about plus or minus 100 days. It's actually considered fast because the Malaysian courts, if any of you have been to the Malaysian courts, you would know that the Malaysian courts KPI is about 9 months. So your claim could take anywhere from 1 year to 5 years. to be settled in court. And with the current pandemic, there's a slight backlog in cases in court. But adjudication seems to be going on well so far because there is no necessary physical hearings for adjudication. It's mostly documentary. It's done by documents, and parties are able to serve the documents either via email, agree to serve the documents via email or in person. So that is really not an issue in adjudication nowadays, but the courts would be slightly slower in resolving cases. This is just a chart or an overview of how the entire process flows. So you have parties, you have timelines for each stage. I will not go much into detail into this process, but at the end of the day, I would just like to highlight at the end of the day, the last step, the decision. When the adjudication decision comes out, the decision has to be served on parties, and the decision will also have to be served on previously KLRCA, but now AIAC. So what happens when parties get an adjudication decision? So today's topic, we are talking about setting aside an adjudication decision. Before we go into setting aside of adjudication decisions, I forgot about this. There are special remedies under CIPAA. So once you get the adjudication decision, the successful party would have certain special remedies. Not usually, if the subcontractor is successful in CIPAA proceedings, then one of the options is to suspend works or to reduce the rate of progress of performance until payment is made to the contractor. The second option is to request direct payment from the principal, which is usually the employer, and bypass the main contractor. So if, let's say, I'm the subcontractor, the main contractor is not paying me for my work, I can forward my claim to the employer and make the employer pay directly to me as the subcontractor instead of paying the main contractor. These two special remedies is only available under CIPAA. You can only use it for adjudication decisions. You can't get a court order and then come back to use these remedies. These remedies are designed especially for the construction industry in order to make payment move faster so that the projects continue and not get stalled. So this is the huge advantages of going for adjudication. Now, coming back to the adjudication decision, there's usually always the successful party and the unsuccessful party. Like I mentioned, successful party would have access to the special remedies under CIPAA. An alternative method of enforcing the adjudication decision for the successful party is to apply to the court to enforce it as if it's a court order and execute it against the non-paying party. For example, you could proceed with winding up proceedings against the non-paying party if they do not comply or pay within the specified time. As for the unsuccessful party, normally after you get the adjudication, you have one of these options. Number one, you either pay, or if you don't want to pay or you can't pay, then the only option you have is to stay the adjudication decision. You can stay the adjudication decisions depending on if, for example, you apply for a setting aside application or you decide to pursue arbitration or court proceedings, which is basically the second round of what our clients usually call the second round. But the problem is the test for stay is also not that straightforward. You might not necessarily get to stay the entire payment. Some of our clients did manage to get partial stays, but that will be up to the court's discretion. So the court will hear parties out on why a stay is necessary, and the whole decision is very rare for the whole decision to be stayed, but it can happen only when there is an unequivocal error by the adjudicator, or there is which means there's a very, very clear error, but that is usually not the case. So it can be done, but the success rate is not that high. So adjudication, I think some of you have probably heard this phrase. It's called pay first, argue later. So this is the phrase for adjudication. You pay first, and if let's say you succeed in your arbitration or your court proceedings later, then which is the argument, then you can claim back for whatever monies you've paid. So this is the mechanism of adjudication. Now, moving on to the next topic, it's how to apply to set aside an adjudication decision. we need to apply to court, and this is set out in Order 69A, Rule 3 of the Rules of Court, which is basically a procedure that your lawyers would be able to handle and to advise you on. You file an originating summons, which is a document to say that you're applying to set aside the adjudication decision, and you have to put in an affidavit in support, whereby you have to state which parts of the decision do you wish to challenge, and other further particulars and details of what happened during the adjudication process. And take note that these setting aside application must be filed before the application for enforcement of the adjudication is disposed of. So coming back to the previous slide, usually this is what happens in court. After getting an adjudication decision, the successful party might apply to enforce it. So that goes under Section 28 of CIPAA. But the unsuccessful party at the same time would also apply to set it aside and to stay the adjudication decision. So that comes under Section 15 and 16 of CIPAA. So at the same time, so you would have multiple applications before the court. And nowadays, courts usually have all these applications heard together. And so at the same time, normally the enforcement proceedings and the setting aside proceedings will be in tandem. Sometimes there are multiple applications, sometimes there are not, but most of the time there are. If you manage to set aside and you want to apply to set aside the adjudication decision, your application for stay can be made by way of a notice of application instead of an originating summons in the setting aside application itself. So it's like a sub-application under the setting aside application. But those are some procedure matters that your lawyers would be able to advise you on if you are applying to set aside the adjudication decision. Now, in order to set aside the adjudication decision, there are only 4 grounds provided under CIPAA that you can set it aside. First one is that you are alleging the adjudication decision is improperly procured through fraud or bribery. Second ground, that there was a denial of natural justice. The third, that the adjudicator had not acted independently or impartially. And the fourth is that the adjudicator has acted in excess of his jurisdiction. So these are the only 4 grounds available to the unsuccessful party to set aside the adjudication decision. The first ground usually fails because of lack of evidence, but we have seen cases, adjudication decisions being set aside more commonly on the second, third, and fourth grounds. As to how these decisions are set aside, I think I'll leave it to my co-speaker, Hannah, later to address it when we look at the case studies. So one thing to note here, the setting aside application is not an appeal against the adjudication decision. Okay, my co-speaker, Hannah, will also address this in her talk later. So I will now pass the floor to Hannah. Hi, Hannah.
Hi, thanks, Denise. Thanks for your presentation. Hi, everyone. As Denise has mentioned earlier, a setting aside application is not an appeal against the adjudication decision. I cannot emphasize enough because if you take a look, or if you're a lawyer, or if you ask a lawyer to take a look at the number of reported cases in relation to setting aside, you will see a lot. A lot of these applications do come in because, but what happens is that a lot of these applications also are really an appeal on the merits of the decision, meaning they're not happy with how the adjudicator handled the decision, the facts of the case. So what the court has said in Court of Appeal in ECFM is that it is not the court's function to look or review the merits of the case or to decide again on the facts of the case, because these the adjudicator would have done. So the court's only function is to look at the manner in which the adjudication was conducted, the proceedings, how it was conducted, rather than what was decided. The court will look at whether there was an error of law during the process. Was there fairness accorded to both parties? So the court will not look at the correctness of the adjudicator's decision. And why is this? Adjudication decision merely provides temporary finality to a dispute. So earlier, my colleague mentioned that adjudication is only rough justice. So rough justice really means I need the money urgently, I get the money from the unsuccessful party, and I continue with my project. Now, if there is more dispute, if this money is not actually due to me later, parties can finally decide it by arbitration or the courts, or the second round. Parties can still resolve these disputes in arbitration and in court. So the court will not disturb the finding of facts if the adjudicator has looked at it. And on that note, I will now look into 5 case studies. Now, these cases are actual reported cases in court, and I will show you 5 different examples of how setting aside applications have been successful. I will only highlight the successful ones due to constraint of time. If you want to have a chat with me later on what makes an application unsuccessful. Now, the first case is also the very first case in Malaysia on setting aside. And I'm very proud to say that we were part of the team which was successful in putting in this application. This concerns a unilateral communication between the adjudicator and one WRP and BlueScope. There was a unilateral communication during the proceedings by telephone call and WhatsApp message between the adjudicator and BlueScope's representative. Now, what was the communication about? The adjudicator wanted to clarify 2 paragraphs in the adjudication reply. And these facts that he wanted to clarify actually was the determining factor of his decision later on. Now, BlueScope actually did bring it up to the adjudicator and say, or rather to AIAC that time, say, look, I don't think there should be one-way communication. The other party should be notified as well. At that time, the adjudicator was of the opinion that he was entitled to unilaterally contact one party without informing the other party. And this, he said, was under CIPAA. Now, if you're familiar with CIPAA proceedings, adjudicators are allowed to ask questions or ask clarifications. The thing is, it cannot be done just with one party. If the adjudicator wants to ask one party only, the communication must be open to all. Everyone should know what the question was and what the answer was. So the court held that there was a duty to inform the other side. The adjudicator had a duty to inform the other side. He should have offered the opportunity to the other party to respond to whatever clarification. So what could have happened in an ideal situation back then was that, okay, I don't understand. I'm the adjudicator. I don't understand what is these 2 paragraphs say. I need a clarification. So I sent out a communication to parties and said, BlueScope, can you please tell me or clarify what this is? And then BlueScope gives me an answer. And then what the adjudicator should have done is tell the WRP, okay, WRP, do you have any comment or do you have further clarification? Do you have anything to say at all about what BlueScope has told me? And then, the WRP at least given a chance to respond to that. So because that didn't happen, the court said that there was a breach of natural justice. If you look at the grounds of under Section 15 to set aside a denial of natural justice, it has happened. Both parties must be given a fair opportunity to present their case. So I hope this is a clear story for you, right? Case study number 2. Now, this is with regards to the failure by the adjudicator to comply with the time to deliver the adjudication decision. If, again, you recall what Denise said earlier, she mentioned that the adjudicator has 45 working days to deliver his or her decision. And this is one such instance where there was a failure to comply with time, also with procedure, and I will tell you why. So in this case, the last day to deliver the decision was on the 26th of March 2020, but it was only delivered to parties by email on the 2nd of April 2020. Now, when parties received the decision was actually dated 20th of March 2020. So from here, you can deduce that the adjudicator actually prepared the decision already. It wasn't released on time. But why was there a delay? Now, there was a delay because one of the parties in that proceedings didn't pay the deposit to AIAC. If you are adjudicating a matter under AIAC, it's the only way to do it. There is fees to pay. There are certain fees to pay to AIAC and also the adjudicator's fees. Everything has to be settled before the decision is released. So AIAC said, can the other party pay on behalf first? And payment was made. It was only confirmed on the 2nd of April 2020. And I would like to note that the payment was paid, I think, on the 31st of March. It was paid, but it was only confirmed on the 2nd of April, right? So can the adjudicator hold on to the decision when payment is not made? The answer is yes, you can. Adjudicator can withhold a decision, but there is one form to fill, which is Form 14. So it's just a form to say, look, parties, I haven't received, or rather there is no confirmation that everything has been paid. I'm withholding the release first. And here, the adjudicator didn't do that. He or she just held on to the adjudication decision. And what happened is in Form 16, now form is another form. Now this form is usually delivered together with the decision. So it's like a special form, a declaration where you say the date of the adjudication decision and when it was delivered. So here the adjudicator declared that payment has been made on the 20th of March, which wasn't the case because, as I mentioned earlier, this person have prepared the adjudication decision earlier but delivered it later. So, they obviously probably signed the Form 16 earlier as well. And the decision, he or she also declared that the decision will be delivered within 45 working days, which is on or before 26th of March 2020. The decision will be delivered within 45 working days, which is on or before 26th of March. So the adjudicator's power or jurisdiction ends or expires on the 26th of March 2020. So what the court said is, because he or she did not comply in actual fact with the 45 days, the adjudication decision is void because the adjudicator's jurisdiction expired on the 26th of March. And therefore, by that reason, there was setting aside as well under Section 15D. 15D is excess of jurisdiction under CIPAA. All right. So that is case study number 2. We now go to case number 3. Okay, case study number 3 is with regards to an adverse inference made by the adjudicator on one of the party based on an SSM search. This is a case where Pesat B was the employer, appointed Geo Hill or GH as its contractor. Chescon was provided PB, which is the employer, with consultancy work. And this is a claim for outstanding professional fees. So remember, construction consultancy contract, it falls under CIPAA as well. So you can claim for outstanding professional fees under CIPAA. So during the adjudication proceedings, there was a clarification meeting that was supposed to be attended by the architect and quantity surveyor. Then during that period of time, Chescon raised an issue of conflict. Now, what this conflict was that Chescon said that PB and GH got relationship because there was some relationship between their director and their shareholders. So what the adjudicator did was he or she conducted an SSM search, but did not show the SSM search to PB. Okay, now, according to what I read, the SSM shows that there was seemingly some relationship between the directors and shareholders of PB and GH. I'm not sure what close relationship this is because the SSM search was not actually disclosed, but that was what was mentioned. Now, during the clarification meeting, the adjudicator didn't say anything about the relationship because essentially this adjudication is between Chescon and Pesat, PB, and GH. So GH had nothing to do with the proceedings in that sense. So it's supposed to be between PB and GH during the meeting, my last point. And in the end, the adjudication decision was decided in favor of Chescon. And the adjudicator drew adverse inference that PB had colluded with GH to reduce Chescon's professional fee. So did the adjudicator act independently or impartially? Was there a denial of natural justice? These were amongst the two grounds for setting aside that was claimed by PB. So PB brought a setting aside application. The court held that procedural fairness dictates that SSM search should have been shown to PB's representatives, whether or not it was material for the proceeding or for the decision. Regardless, it should have been shown to PB's representative. And parties should have been given the chance to comment on the information on the SSM search. And the court also observed that the adjudicator drew adverse inferences arising from the purported close relationship between the directors and the shareholders. And these relationships appear to have created a certain impression in the mind of the adjudicator. So again, I would like to emphasize it's whether or not it's material to the issues of the adjudication proceedings. What the adjudicator should have done is, again, open it for parties to comment. Whether or not it should constitute a conflict or not is something that can be decided later on. So this was not an opportunity that was given to parties. Okay, and because of that, court said that there was a breach of natural justice, so setting aside is allowed. Case study number 4 is an issue about core jurisdiction. Core jurisdictions will relate to what is important to be decided even before the adjudicator take on the matter. So if he or she didn't have the power to decide even back then, he shouldn't have taken up the matter and decided. Now, this is a case between High Form and PBT. So PBT appointed High Form, and the claim was brought by PBT against High Form for rectification work and completion work, and LAD for late completion. Okay, so in here, High Form was the subcon. The adjudicator allowed the claim, and High Form applied to set aside because PBT's claim is not for payment under CIPAA 2012, and there is an excess of jurisdiction. So let me just go back to see what was PBT's claim. PBT's claim was for rectification and completion work and LAD. Now, according to PBT, these are all claimable under the contract, which the court admitted, yes, these are allowed to claim under the contract. But can you claim it under CIPAA? Okay, that was a question court had to deal with. And High Form actually raised this issue of a jurisdiction or challenged the jurisdiction of the adjudicator during the proceeding itself. But as CIPAA is a very fast process, so to speak, the adjudicator decided on the jurisdiction and say, I will still go on and decide. Now, even if this happened, court can revisit the challenge afresh, and court can set aside the decision because the adjudicator lacked the requisite core jurisdiction. Now, what happened here is under sections 4 and 5 of CIPAA, payment is only for unpaid work done and or for services rendered. It does not include unpaid debt or damages arising from a breach of contract. Now, if you're a party for the respondent, you may have said, hey, but I put in LAD before. Yes, you have, but not as a claim, mostly as a cross-claim or set off, because that is allowed under CIPAA. You can set off the claim by the subcon, but you cannot put it as a claim in itself. All right? So the court said that PBT's claim for rectification or additional completion costs are damages which flowed directly from the breach of contract. Yes, so again, it may be a breach under the contract, but it's not for payment for work done that makes it eligible for a CIPAA claim. So the court then said that there was a problem with the core jurisdiction. The requisite jurisdiction was not there, so the adjudicator could not have decided on this matter. Therefore, it got set aside. We have a final case study. which also, a cue for me to tell you, if you have questions, please put it in the Q&A box and we will attend to them. So finally, denial of hearing. Now, hearing is not compulsory, and if anything, if you heard Denise earlier as well, everything is document-based, right? You have a set number of days and everything should be completed within 100 days. Sometimes hearings are given, especially if there are experts involved and you want to cross-examine these experts. And hearings sometimes are allowed and sometimes are not allowed. Now, when I say denial of hearing, I don't mean all denials of hearing will be. Okay, it really depends on the facts of each case. And this is one such case where the denial of hearing caused the adjudication decision to be set aside. This is a Court of Appeal case, and it overturned the High Court decision. Here, the aggrieved party was the appellant, Wong, and he was the respondent in the adjudication proceedings. So High Court dismissed Wang Xi's setting aside application. And in this Court of Appeal, the Court of Appeal said that there was denial of natural justice when the application to call 3 expert witnesses to give evidence was rejected. So there was an application for hearing. This application was made 1 day after the adjudication reply. So that means it is day 1 of 45 working days. So this application came in at day 1, which is right after the adjudication reply of the 45 working days given to the adjudicator to decide. So why did the adjudicator reject the application for hearing? There were 3, but I'm only going to put the one that is relevant here, which is time. So this adjudicator said, there's only 45 working days. I have very limited time under CIPAA. Because there is a time constraint, I don't want to hear parties. I don't think it's necessary to hear parties. There are other reasons she gave, which contributed to her denial of that hearing, but this is one of it. And the court said the application for hearing, oral hearing, must be considered on its merits. So, as I said earlier, not all denial of hearings will be considered a denial of natural justice. Okay, you must look from case to case. But the court also said a hearing cannot be denied purely on the ground where time is limited. And I put a quote here, which I think was very important. If all applications for an oral hearing are rejected on the timeline argument, then the power to order oral hearings under Section 25 of CIPAA would be rendered illusory. What this means is that under CIPAA, parties are allowed to have hearings if they ask permission from the adjudicator. So if each and every adjudicator used time as an issue, then what's the point of having the provision for hearing? So that's the court's argument or reasoning. And the application was made at the earliest opportunity, as day 1 of day 45, right? And as we all know, there can be no appeal and no finding of facts that can be challenged. If parties decide not to go to arbitration and court proceedings in the future, I guess this is it. So there is no chance anymore. So it is of great importance that all assertions put forward in opposing an adjudication claim be considered in the adjudication proceedings. And then the court went on to say that the breach of natural justice is a material breach, and the applicant must show that there was real possibility that there would be a different conclusion if an oral hearing and all matters raised was considered. So in this case earlier, if you see this, 3 expert witnesses were supposed to be called. And the court said that there was at least some technical issues which warranted fair consideration. So the court said, okay, so the application was made early. There were some technical issues that might, be raised. Considering in the grand scheme of things, hearing should have been granted. And on that basis, the appeal was allowed and the adjudication decision was set aside. I hope you have learned something from these 5 case studies. And if you have any questions, please don't be shy to ask. I'll pass the time back to Chee and Chien.
Thank you, Hannah. So thank you to both our speakers, Hannah and Denise, for sharing with us thoughts on setting aside an adjudication decision. I hope everyone here will find it insightful. We will now move on to a Q&A session. We will now take questions from the participants in the Q&A box. There's a question from Nasim Amir Ali, which is asking that some, not all of these issues that ended up in court appear to be very basic issues or common sense issues. Should the lawyers just pursue any case that the client asks them to, possibly wealthy clients, or should they carefully consider the case and advise their clients not to pursue frivolous cases? Maybe Denise, you want to take on this?
Okay, thank you, Chen. Well, usually what we do is, we always advise clients on the merits of the case and not to pursue any frivolous cases. And we always analyze clients' cases on a case-by-case basis. But remember that there is always two sides to a coin. So what might appear to be common sense to one person doesn't necessarily appear to be so or to be common sense to another person. So it really depends on which stance and which position and risk perspective are you coming from. So at the end of the day, the decision, we will advise client on the merits of the case, and it's up to the client to make the decision whether or not to pursue the action in court. So, and if let's say clients do decide to pursue the action in court, then we have what, as we have seen just now, the case studies, the reported cases, which will then lay out the principles of the law for the benefit of any subsequent contractors and parties as a reference. So based on case law, we can roughly know what the court's stance is on certain issues, and we will advise clients accordingly. So it's definitely not a pursuit of frivolous cases. So that's what we lawyers usually do. Okay?
Right. Thanks, Denise. We have another question here. Question from Mr. Chee, I assume. Can a dissatisfied party raise new issues or facts in setting aside application when these issues or facts were not raised in adjudication proceedings and therefore not considered by the adjudicator? Hannah, you want to take on this question?
Thank you for this question. I will give you a very short and a very long answer. The short answer is no, you cannot. But imagine you're the adjudicator and these are the facts before you and you have considered everything. And if in the setting aside application, you say that I have breached my natural justice or have access of my jurisdiction because I did consider for something you didn't bring up, that's not really the adjudicator's fault. So parties, if you want to be sure that you cover everything, do it in the proceedings. Don't do it in a setting aside application. Now, if you do want to go for a more extensive study or scrutiny into the facts, then go for arbitration or court proceedings. You don't have to spend that time and money in a setting aside application.
Thanks, Hannah, for answering the question. So if there are no other questions from the audience, I will just end the Q&A session. I would like to thank our speakers again, Denise and Hannah, for your insights on this topic, setting aside an adjudication decision. Before we conclude today's talk, I have a few announcements to make. Firstly, if you can see the screen here, please join us for our upcoming talks. So there is one on the 23rd of March. The topic is the offense of criminal intimidation and your rights during a police arrest, remand, and bail. And our senior associate, Ms. Vivian, will be speaking on this. And there's another talk coming on the 6th of April, which is trademark infringement and passing off. This will be by Hannah and also our partner, Leslie. I believe the link to sign up for the talk has been uploaded in the chat. Now, secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat box as well. Thirdly, do follow or like our social media accounts. If you can see our screen here, we have YouTube. All of our talks will be uploaded on YouTube as well. Twitter, Instagram, LinkedIn, and also Facebook. Now, if you'd like to speak with our lawyers, if you have questions that you didn't get to ask just now regarding this topic, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website. I think the link is also posted in the chat box. To our guests, thank you for joining us for today's talk. We hope you found today's session informative and useful. Thank you, everybody, and hope to see you in our next talk.